Meeting and just advise everyone that we are audio and video streaming this meeting live on the YouTube channel, and it's being recorded as well. If there's any elected member who hasn't signed in to the meeting in accordance with our COVID-19 safe plan, please do so now. I request that all mobile phone devices be put onto silent or switched off. And for the purposes of recording, elected members should wait for myself to announce them before speaking. I note that everyone is present, although Alderman Sexton is online on Zoom, which is still allowed under our COVID emergency orders. Yes. And so there's no apologies, there's no leave of absences. I'd like to start with our acknowledgement to country, which is that in recognition of the deep history and culture of this place, I'd like to acknowledge the traditional custodians of the land upon which the city of Hobart was built. I acknowledge the determination and resilience of the Palawa people of Tasmania, who have survived invasion and dispossession and continue to maintain their identity, culture and rights. The minutes of our meeting on the 9th of March, moved by Deputy Lord Mayor, seconded by Councillor Ewan. All those in favour say aye. Against say no. Carried unanimously. Are there any items proposed for the transfer on either the open or closed portion of the meeting? There being none, we don't need to do that then. Are there any public questions? Are there any petitions? Goodo. And supplementary items? No supplementary items. Okay, item 8 is indications of pecuniary or conflicts of interest. Do any elected members wish to declare any interest in an item appearing on the open council agenda? Alderman Brackus.
Thank you, Lord Mayor. Item 9.3.
9.3?
Yep.
Okay. Any others? There being none, we will move on now to the City Planning Committee. I note that the Council is now acting as a planning authority, and I'll invite the Deputy Lord Mayor to introduce item 9.1, which is number 7 Nixon Street, Sandy Bay.
Thank you, Lord Mayor. This is considered under the City of Hobart Interim Planning Scheme and it's for partial demolition and extension. I move the recommendation from committee for approval.
Seconded by Alderman Thomas.
You might remember that this almost came to council back in December or early January. It certainly went to committee at that stage and was a tied vote. So the recommendation from officers was that on heritage grounds this should be refused. 7 Nixon Street, Sandy Bay is a site corner of Nixon and Marsden Streets, Sandy Bay. And the intention is for modifications to a family home at the rear of the building to add an upper floor with skylighting for a master bedroom, as well as front and side fencing changes. As I said, the officer recommendation was to refuse based on heritage grounds. The applicant the item was deferred before it got to full council. And there were some modifications in relation to roofing, but the modification in relation to changes to the side wall was not acted upon, if you like, that request from the heritage, or to make it heritage compliant. So whilst there are some internal changes to change 2 bedrooms into a living room downstairs, what will be downstairs, were deemed acceptable. There were concerns raised by the heritage officers on the impacts on street view from the extension and addition of a window that wasn't a sash window to the Marsden Street side of the building. There will be some impact for residential amenity on 9 Nixon Street with the first story addition. However, that's not it's only at the winter solstice, and I think it's purely for a very short, relatively short period of time. So residential amenity impacts was not considered. The committee has recommended for approval, subject to conditions, including the roof colour requiring further approval from the director. So it wasn't unanimous, but passed committee 5 votes to 1.
Okay, any discussion? There being no discussion, I'll put that. All those in favour say aye.
Aye.
Against say no. Show of hands, all those in favour.
Alderman Zuko, Alderman Sexton, Councillor Harvey, Councillor Sherlock, Councillor Coates, Councillor Ewan, sorry, Alderman Barikes, Alderman Thomas, Alderman Briscoe, the Deputy Lord Mayor and the Lord Mayor.
Against?
Councillor Dutta.
That's carried, Lord Mayor, 11 votes to 1.
Okay, moving on now to item 9.2.
Thank you, Lord Mayor. This is also under the City of Hobart interim planning scheme. It's 118 York Street, Sandy Bay, and adjacent road reserve partial demolition subdivision of 1 additional lot and associated works. I'll move that.
Second, Lord Mayor.
Lord Mayor, this we return to the Golf Links estate in Sandy Bay, and this is a lot of just over 1,000 square metres on the southern side of York Street, which is 60 metres from the Proctors Road intersection. There's subdivision of these Golf Links estate blocks are not usual, partly because of the lot size, but also not having rear access, which is accessible given the position of house and the size of frontage on this block. So the pattern of development, as we have been refreshed of late with the 19 View Street case, has been of single houses with large backyards, so very few subdivisions in this area. So the proposal is for a 544 square metre a balanced lot, which includes the existing house, and a 460 square metre for lot 1 block at the rear, which includes a 3.6 metre wide driveway. And whilst there are a number of discretions that are triggered, there has been an attempt over many months by the developer to reduce the impact on direct neighbours of any future development on the proposed subdivision. We're only considering the subdivision at the moment. And interestingly, there's a suggested Part 5 agreement, which the applicant has agreed, subject to this being approved tonight, that any proposed development would be no higher than 4.5 metres and would be set back, so the impact from the street view would be limited. So it's really to reduce the visual impact from the street. The application is for a driveway to the east of the existing building, creating this battle axe block. And so the Part 5 agreement essentially satisfies E 13.8.3 A, B, C and D clauses, which really has that reduction in impact from the street view. Thank you.
Further discussion? No discussion? Can I just ask a question before we vote? Just there was some question raised in the committee meeting about the legal sort of strength of Part 5 agreements, and I know the existence of that agreement is somewhat of a comfort to the representors. Can you just clarify on the record how legally binding Part 5 agreements are?
Lord Mayor, although bound by the Land Use Approvals Act and Section 7 under that Act, so they're enforceable through the Supreme Court, and clearly having it on the title gives some, I suppose, prior warning to purchasers that requirement is in place and has been put in place by council. So it's a worthwhile exercise. It should give some line of sight to purchasers and some comfort to the neighbours.
Okay, did you want to sum up at all?
Yeah, just a quote from the report regarding that: the signing of a Part 5 agreement would effectively place a non-negotiable legal control over the land, providing certainty over the maximum height and location of future development.
Great, thank you. All right, I'll put that. All those in favour say aye.
Aye.
Against say no. It's carried unanimously. Item 9.3, 26 Tabart Street. Alderman Barakis is declaring an interest.
This is 26 Tabart Street, Newtown, 2 multiple dwellings. It's recommended for refusal because it does not entertain the current pattern of development in the Scarrington Park subdivision and will have a deleterious impact on neighbouring properties, which is based on 2 clauses. One is density. It's 2 dwellings, not 1 dwelling, which is the usual pattern in this new subdivision, and relative bulk and scale of the There were 3 representations, and they were concerned about the resulting loss of amenity to their properties, effectively adjoining.
Okay, further. Seconded by Councillor Harvey. Any discussion? All those, I'll put that. All those in favour say aye. Against say no. Carried unanimously. Item 9.4. Oh, sorry, wait for Alderman Barakis to come back. And the next item is item 9.4, which is 20 Runnymede Street, Battery Point, appeal. Just a minute. Deputy Lord Mayor.
Thank you. Lord Mayor, this is considered under the Sullivan's Cove planning scheme, and it's in relation to the Lena appeal, as you said. The proposal for further development at Lena returned to the committee last week. It was first determined by the council on the 17th of December 2018 as a refusal on 2 heritage grounds and 1 planning ground. That decision was appealed by representatives to the tribunal. As part of the appeal, the applicant sought to amend its application. The tribunal allowed it to do so and decided that no further public involvement was necessary, and I think that was under section 22 of LUPA,
Resource Management Planning Appeals.
through REMPAT Act. So the application has returned to the council so that it considers the amended application with opinions from heritage and planning officers. The council's role at the moment is as a party to the tribunal appeal, so we're not making a decision on the current proposal. The tribunal will make a decision after a hearing on the merits on the 25th of May. At committee, as you would have read in the report, which is now on open, but was first considered on the closed agenda, 3 options were proposed to the committee. Option 1, which is what was taken, was continue to refuse the application, but only on the 1 planning ground, since it is now supported by the heritage officer. So the heritage officer or consultant, Mr. Brendan Leonard, now believes that on heritage grounds it suffices. So this recommendation was adopted and is what we have before us. Option 2 was to continue to refuse the application on both heritage and planning grounds, but this was not supported, and I'll give reason for that. Option 3 was to support the approval of the amended application and suggest to the tribunal that a permit should be granted, but this wasn't supported. So having 1 refusal ground means that the council would amend its refusal grounds in the appeal so that it only refuses on a planning issue, not heritage. It is highly likely that the joined party, Super Woolstore Proprietary Limited, would apply to the tribunal for the heritage issues to continue to be considered because his his heritage expert, Mr Graham Corney, is of the view the amended application does not satisfy the planning scheme. The council would most likely only submit evidence to the tribunal on the planning ground and would not file heritage evidence. As such, it is expected that the heritage issues will be considered by the tribunal at the hearing, even if those grounds of refusal are dropped by council. However, the council would remain neutral on the heritage grounds by not actively supporting the proposal or challenging the party joined. We got the council officers, or Ms Abey in this case, got legal advice because there's this argument that heritage would take precedence, but if the council decides to drop the heritage grounds, that would not undermine the remaining planning ground. The grounds and the evidence in support have been reviewed by Ms Billett, the council solicitor, who specifically reviewed the potential for conflict between the heritage and planning grounds, and she was satisfied that the planning ground could be independently maintained. Ultimately, the tribunal will need to be satisfied that all aspects of the scheme are satisfied in order to approve the proposal. So this was heard last week. We heard from representors and the applicant and their representatives at committee. So for those of us who could attend that, I think that was quite useful to hear both sides of the argument. So not clean cut, but certainly a decision that we have to make tonight.
Other discussion? Alderman Barakis?
Thank you, Lord Mayor. I don't support the motion that came from committee, and in fact I think I'll foreshadow that the council adopt option 3 that was on the committee, that we approve the amended plans. I think this was an application that I think should have been approved when it came before council in 2018. And I think if we're just looking at what we've got in front of us tonight, you know, we talk about whether or not the application appropriately conserves the traditional urban pattern of Sullivan's Cove or reflects the natural topography of the planning area. If you sit back and look at the topography of the area, you have 2 very large buildings right next door to where this will be built, and then metres away you have the silos building, which is higher than what this proposed building will be downhill. That being, it's set quite a way further down the hill, and the top of it comes up quite a bit higher than what this development will come. So to suggest that this doesn't sit in or is overwhelming the area when you have already the 2 Leonard buildings which sit further up the hill and will be situated higher than the proposed development, as well as the silos building that once again is many times larger than what's being proposed. I think it's a bit rich to suggest that what we've got here is of any substantially higher than what we currently have there, volume or mass. Now I will just briefly read out a small excerpt from the RIMPAT decision, or the RIMPAT report, sorry. With respect to the submissions from the first party, joint and council, the tribunal cannot envisage the interests of any one of the parties, developer, joint parties, council, the general public being detrimentally affected by the application being granted. Although the application before the tribunal discloses many minor changes to the proposal by way of amended plans. This, you know, if you read the report, Lord Mayor, and you read what RIMPAT said, it's pretty clear from the language, whilst I haven't yet made a ruling on or made a decision on this application, what their perspective is on the application. And, you know, if I was a betting man, I'd be betting that if we decided to continue to pursue this at RIMPAT, the answer that we'd be getting back in the month's time would be very similar to what we've been getting back on quite a number of other planning applications that end up in tribunal. That being that we then required to accept the decision of RIMPAT and overturn our decision and allow approval. The cost of that will come at a great cost to the ratepayer and a great cost to you know, getting things like this, which should be approved in the first place, approved when they should be and not being delayed by 18 months or however many months. So, Lord Mayor, I think, you know, the writing's on the wall as far as this. If we do decide to pursue it with RIMPAT, I think we should be responsible with how we're spending the ratepayers' money in pursuing this. And I think we should do the right thing and allow this to go through, because I think it is actually a worthy and appropriate development for the area. So I'd be foreshadowing that we adopt instead option 3 and approve the amended application.
Before we move to Alderman Zuko, is there a seconder for the Deputy Lord Mayor's motion? Alderman Zuko?
Yeah, Lord Mayor, I just have some questions through you or the General Manager, the appropriate officer. The former Senior Cultural Heritage Officer, Mr Brendan Leonard, could anyone advise me what his position was at the original approval or not approval of this application?
Mr Noy? Do you know the answer to that?
Yes, he was of the view that it didn't satisfy the heritage provisions of the scheme.
Okay, is Mr Leonard engaged by council for this appeal?
He is, for the purposes of the assessment today.
And what's the current position of Mr Leonard, considering that at the original he set out for refusal? What's the position of Mr Leonard now with the amended plans?
His view is that it complies with the relevant heritage provisions of the scheme.
Thank you very much.
Further discussion? Councillor Coates?
Thank you, Lord Mayor. Look, it's a difficult one, as a lot of these bigger commercial, if you like, developments are, because ultimately every development, as we know, is unique, and the scheme is relatively subjective, and it's asking us to consider things such as the size, the form, the scale. Look, when you go down there, you can look around and see neighbouring buildings, go, oh, this one's going to be smaller than that, and try and make your assessment, or you can obviously read the expert's report. In this instance, though, what we have is a little bit of a history. So we've had an original application that we heard was put forward. The council officers recommended a whole range of reasons to reject. And then the applicant, as I read it from the presentations that were given, has actually gone around and made, and I asked this question of them specifically in committee, they've made significant changes and come forward with a new proposal that's been quite significantly changed, both in its size, its shape, its setback and form. And not only that, they've actually gone away and they came back and they've got experts who provided advice to say, look, this complies. Now, I agree, there's experts on the other side who've also got advice to say it doesn't comply, and so it puts us in a bit of a pickle. We always work on the advice, but our goal as a planning authority ultimately is to try and implement the planning code. And in this scenario, I can see where something's come forward, it didn't comply, the applicant's then done the right thing, it's gone off and got the advice, amended their plan significantly, it's gone off tribunal and it's come back, and now we're trying to make a decision as to whether we carry forward that refusal. And as I read it, I think they have made a significant change to their proposal. They have engaged experts that have given them advice to that effect. They have made changes, they've knocked the whole story off the building they're proposing. And as I see it, honestly, my view is that I think it does fit, and I think if it does go forward, we will lose on appeal. But ultimately, I think our role now in this process should be coming to an end. Council should be dropping its objection to this. If the other parties want to continue, that is their right. And they can do it, as we've heard, on heritage grounds as well as on the size grounds. And so, look, I just think with this, I'd foreshadow again, not the one that was passed by committee, but that council actually vote to cease their involvement in the refusal, because I think it does actually fit it, and we heard a history, if you like, of where they've actually gone and done the right thing and amended their proposal to fit within the scheme and got expert evidence to that effect. And if others want to continue taking it up, that is their right, but I don't think we should be putting Hobart ratepayers' money on the line. Thanks.
Lord Mayor?
Oh, Alderman Sexton.
Yeah, thank you, Lord Mayor. I'm sorry to not be there, putting my hand up. The issue of whether the amendments that have been made to the plan are significant or not was, as I understand it, one of the matters that the tribunal was asked to deliberate on. And it's my understanding, and I'm happy to be corrected, is that the applicant argued that the changes were not significant. And they argued that they were not significant in order for the tribunal to decide that they did not require to submit a new development application and therefore advertise a new development application publicly. So, if that is correct, and I think it is, then both the applicant and the tribunal have argued that the changes, the amendments were not significant. And if they're not significant, then I see no reason why I would be changing my view on this matter, which will be to support refusal.
Alderman Briscoe.
Yes, a very similar point as Alderman Sexton has just raised. Have we got any ability or power through you, Lord Mayor, to the General Manager here or the Director, to ask for the application to go out for public, a new application to go out to the public for their input? Because it's been over 2 years since this application came before us.
Mr Heath.
We do not, Lord Mayor. We are following proper process here. We do not have that power.
So the proper process ends up disenfranchising the public.
Look, Lord Mayor, through you, the public had their say initially back in 2018. This process that we're now dealing with tonight is a process being run by the Resource Management and Planning Appeal Tribunal and not this council. So the applicant put in an appeal and we're running a process now in accordance with that. So I do note though, through you, Lord Mayor, that the Deputy in introducing this matter did make the comment that the item was placed on an open committee agenda.
That's right, and we are here as an applicant, not an applicant, as a party, and deciding our position. I believe that we still have to maintain our opposition to this development, and we've got numerous correspondence the last couple of days where people of very respectable professional background asking us to make sure that we maintain our objection to this, and the officers agree. Just a question I have read in one of the emails that we got is that what is the height limit for this particular part of where the development is going? What's the height limit for that?
Mr Noe, did you want to answer that, or Ms Abbey?
Look, I understand it's 12 metres, but I'd need to confirm that.
Yeah, so look, my understanding it is 12 metres as well. So, and this is the revised, it is 20 metres. So to me, the Empress Towers a few years ago, quite a few years ago, protected Battery Point from towers that would go all over Battery Point. And I think we've got to think the wisdom of our forebearers, excuse me, has to be protected. And I'd say I am disappointed that we have no power to send it out to the public, and it's not our fault, as the General Manager has pointed out, but I also think we have ability to help the residents and other people who are concerned about protecting Battery Point to maintain our opposition to this. Thank you.
Okay, further discussion? Any further discussion? No. All right.
Look,
let's sum
Lord
up.
Mayor, I wasn't going to speak, but I'm going to speak. I think everyone knows my position in regards to the amount of money we spend going to tribunals and the amount of money that's spent in respect of defending sometimes decisions that are made here, and we get predominantly these matters come back to us in closed council. It actually frustrates me. I'm actually quite torn here in the sense that we have our former head of our Heritage Division, who would have been the most I hope it's not detrimental, most precious heritage officer I've ever seen in all my years of being on this council. This officer now, this former staff member now, is representing the council at the tribunal still on behalf of this council, because he was the officer that oversaw the actual application and actually originally recommended to this council to refuse the application. I've got to say, and this is one of the things that I actually had a little discussion with a fellow elected member on this. A lot of the time when we get something back from the tribunal, it's, to me, a flag for us to consider that item seriously. And I suggest that we do consider this item seriously, because when we've got the actual heritage person that recommended that we shouldn't approve this, who's representing this council, remember this person's going to be giving evidence at the tribunal. He'll be asked questions. He'll be asked potential questions on why he refused it on the first place, and be asked questions why he's accepting it in this instance. If that in itself is not detrimental to this council at the tribunal hearing, and I've got nothing to understand about how people give evidence. That seriously concerns me. And as I said, and I've pointed out many, many times, the tribunal is not sending us something back merely for us to look at it. They're sending it back to us, and I believe they're sending a message like they normally do. I am a betting man, and I would love to find a book on this one here. But if I put my dollar on it, it'll be my personal dollar that goes on it. But what we are doing now is going to be risking further council funds and further ratepayer funds to fight a battle that I feel we will lose, and in particular, when you read the report. General Manager, can I quote from this report? Can I? Or just open now or not? Or I don't know anymore.
It is open, Lord Mayor.
It is open, Lord Mayor. That's good. Council's former Senior Cultural Heritage Officer. Senior, not junior. I thought we had an argument about junior lawyers a couple of weeks ago and senior lawyers and SCs, but this is a senior person. This is a senior person, been on this council many, many years, and I've got to say, I'll admit, I called him precious a few times over the years. Remains engaged by council for this appeal. Mr. Leonard has considered the amended plans and advised he now supports the approval of the application. And in summary, he concludes, the height, scale and bulk of the proposed new building as amended is now more responsive to the immediate context. The amended proposal achieves a more respectable relationship with the 1973 hotel building with its neighbours. It is considered that the various modifications made to the design proposed building and the reduction of height and setback make it difficult to sustain the grounds of refusal with respect to the planning scheme in cultural heritage provisions. I rest my case.
Can I just ask a couple of questions before we go on? Oh, sorry, Alderman, Councillor Dudley, did you want to speak?
I wanted to ask questions.
Okay, you have questions first.
Thank you. Through you, Chair, with regards to the change that has taken place by the Senior Cultural Heritage Officer, is it based on the fact that he has considered the same set of facts, or he's changed his position because of altered amendment set of facts?
Mr. Noy?
Yes, Lord Mayor, he's changed his position because there's been a change in the proposal.
So I may as well stay put, I think. Councillor Dudley's got more questions, so. Dudley, did you have other questions?
Thank you. Now, the fact that he has made a change in his position and recommended that we support it is based on the fact that it is no longer the heritage ground we can use because of the changes that have been made.
That's correct.
Thank you. Can I speak now, please? Yeah. Thank you. Now, it is very clear then for me that when you listen to the debate that has been presented, it distorts it. The change has been made by the senior heritage officer as presented to us in the report is based on the fact that the facts have changed. And when the facts change, here is a man who is now changing his position. That is quite logical and legal and acceptable. But to come here and say that the same officer and make implications or ramifications that this man has changed his position and not say why can be a bit misleading. Now, the second point for me is this, that the recommendation has been made to us by a legal advice. We have looked at the two experts' advice given to us, and for me, it is very clear that I'm accepting now the cultural heritage advice. However, my reason to oppose this is based on the planning reasoning, and that is very clear from the report. Thank you very much.
Further discussion? I've got a couple of questions. Mr. Noy, can I just ask a couple of questions, please, just to clarify? I'm just wondering, the Rampat decision, is that the Rampat decision? Was that a judgment about the merits of the new proposal, or was it more about the need or not to re-advertise? Because there was a suggestion that Rampat kind of sent us a message in the judgment about what it thought about the proposal.
Yeah, this is a judgment in relation to Section 22 of the Rampat Act, which is simply a matter of whether they were prepared to accept an amendment to the plans for determining the appeal. So it wasn't necessarily a judgment on the merits or otherwise of the proposal against the planning provisions. It was simply a judgment on the merits of whether the amendment was significantly different or not to that which was originally determined by Council.
All right, that's good. So that's just sort of clarified for me that they haven't sort of sent us some special signal through their judgment.
No, I don't believe so.
Okay. The other thing is just related to the, if we proceed with the recommendation of the staff, which I think was that we only take forward a couple of planning items, not cultural heritage items. Would it be my understanding that our cultural heritage advisor will not be part of our case at all? It'll be other evidence and other witnesses?
That's right. We can remain silent on those heritage matters because we believe that it's compliant.
So his role in this won't really be in it, but the advice of the staff was to proceed with a option 2, wasn't it? Which was just certain planning matters.
That's correct. Our position is that only the planning matters are justifiable reasons for refusal in this instance.
Yeah. All right. Look, I have read the work of some of the work that's come in from representors. I've read also the information from the developer and the staff report. I am a little bit disappointed that we're not still taking forward heritage concerns, because I do think the Sullivan's Cove planning scheme, which has protected the area, I think Alderman Briscoe mentioned, was it for 50 years or more. It is a really important precinct, a heritage precinct, and when we think about risking ratepayers' funds and risking risking things. I think we have to think about the risk to Hobart, the risk to Hobart's character, the risk to Hobart's brand, the risk to a really fundamental world-class precinct, which is Salamanca, if we approve something that is not complementary and actually enhances the heritage character of the precinct. And that's why I found Mr. Corney's information quite compelling, that the heritage is actually meant to take precedence in this particular precinct because it is so of such national and international significance, and we are the guardians of this really important precinct, not just for the current residents but for future residents, and for not just residents but visitors and everybody who loves those really key elements about Hobart. So we have to treat this precinct incredibly carefully and be very judicious, and I think there are still major concerns. I acknowledge that the proponents have made some changes, but I don't think it's anywhere near up to scratch for this precinct. The height is still over what is required. The bulk on either side is significant. It will be like a big wall and will really change the precinct quite substantially. So I wasn't sure whether someone was going to move that we amend and add those heritage elements, but it doesn't look as though there is. I probably would have supported that, but I do hope that those arguments are strongly heard by the tribunal as well.
Lord Mayor, I wouldn't normally speak after you, but I'm not disagreeing with what you said. I find it's a really difficult application. There is an inadequate set of recommendations from officers, in my opinion. It's a very confusing set of circumstances. Yes, I could have gone and listened to the planning committee on this one, but I do take into account that it's away from Salamanca to a degree, and in front of it, it's not going to affect the vista of what are basically apartment buildings in front of it, single story admittedly. It's a very difficult decision. I have absolutely, probably in all of the years I've been here, I've got no real foundation as to where I should hit. I do appreciate that the building is scaled back. I do appreciate it's not sitting in Salamanca. I find myself in a situation that because I have some doubt as to the logical nature of us continuing on the appeal because of the way I'm feeling, I have no alternative but to vote against the recommendation that appears in the papers. And it's principally through you to the director, because I don't have a firm foundation. I feel that we haven't been given enough lead here. This is quite a contentious set of circumstances. Whether or not there's some mysterious covert messaging coming from the tribunal or whatever it is a most difficult set of circumstances. And I appreciate that there are people, including people in this room, who think it should be re-advertised. But as I said, I think we do not have a proper set of recommendations. We do not have a proper briefing for what is a very contentious area of planning law. Thank you.
Sum up, Deputy Lord Mayor.
Thank you. And just in relation to those comments, well, it is difficult, as you suggest, Alderman Thomas. Our job isn't easy, but I would have to say that the information provided by the officers and by Ms Billett certainly satisfies my concerns, even though we're dealing with the Section 22 from the Planning Appeals Act, which makes it very grey for applicants or representors to feel like they really have any sort of say when things go into the vortex that is the Planning Appeals Tribunal and spits out something quite different. So there is reason to think that things might have to be changed in order to have some sort of fairness. But that's not what we're considering tonight. We've heard, I think succinctly by Alderman Zuko, that we're not considering heritage issues tonight as part of this recommendation. It is purely on the planning ground. So I thank Alderman Zuko for clarifying that. And we are looking at something that is not, as Alderman Barakis has suggested, it's not a comparison of the silo buildings, it's a comparison of the buildings which make up Lena, so the original Lena, but the contrasting 1970s building as well. So here we have a decision tonight. It's not an easy decision. It could go either way, I'm thinking. But really this option to continue to refuse the application just based on planning grounds alone is what the advice, as I said before, is what the legal advice is. So that's what I'm moving.
Okay, I'll put the recommendation. All those in favour say aye.
Aye.
Then say no.
Aye.
Show of hands, all those in favour.
Councillor Dutta, Councillor Sherlock, Councillor Ewan,
Councillor Alderman Sexton.
sorry, Lord Mayor, Alderman Sexton,
Can we start again?
Alderman Sexton, Councillor Harvey, Councillor Dutta, Councillor Sherlock, Councillor Ewan, Alderman Briscoe, the Deputy Lord Mayor and the Lord Mayor.
Against?
Alderman Zuko, Councillor Coates, Alderman Barakis and Alderman Thomas.
So, Lord Mayor, the recommendation is carried 8 votes to 4.
Moving on now to item 9.5, 51-1 Collins Street.
Lord Mayor?
Yes, I do.
Lord Mayor, this is... actually, I might get somebody else to move this. Perhaps Alderman Barakis, could you move this, please?
He was going to vote against it, wasn't
Oh.
Oh, no.
Alderman Barakis?
I'm happy to. Thank you, Lord Mayor. This is an application for change of use of visitor accommodation. It comes under the Sullivan's Cone planning scheme. I'll move that.
Seconded by Alderman Zuko.
Thank you, Lord Mayor. Lord Mayor, this is a motion to approve an application for change of use to visitor accommodation at 51-1 Collins Street, Hobart. This is an application that was recommended for approval by the planning officers, and it was passed with amendments by Alderman Briscoe, namely being that there be a time limit placed on the duration of the permit for 2 years. Given that there are some, I suppose, not uncertainties, but there are some concerns throughout the area. But ultimately, this is an application that does meet the requirements of the planning scheme. There were some concerns raised by neighbours in regards to potential and potential impacts such as noise, such as some other things that were raised. However, I think the committee was of the view that an adequate management plan, adequate point of contact for residents to raise their concerns, to bring these concerns to the attention of the applicant or whoever is managing the property for the applicant, is a good way to address this and to balance that out. And if there's enforcement action that needs to be taken by the council or by the police, that's something that we could always assist with. I think it does need to be stated that this isn't a case of a house coming off the rental market. This is a house that the applicant, as he stated, has owned for I think it was around a decade. I could be wrong, but it was about the period of a decade, potentially more. That he bought well before short stay accommodation was even a thing. That he does use to host or to accommodate his extended family when they do come down here for periods of time, sometimes for months. And does sit dormant in the meantime, and this is just an attempt to try and make that financially sustainable. So I think that is something worth noting. This isn't something that will be removing any housing stock or rental stock. I think there was comments, and there were comments made, I think, the last time a application for this came up just very recently in the same complex, about what does constitute a dramatic change from the existing use being residential. And I think that is something that we should be proactively looking into and trying to get some advice on. I think at the moment though, this application, should it be approved, would take the makeup of residential to short stay in the complex from 7% to 9%. So, you know, even under the language of the planning scheme, the language of the regulations there, this doesn't constitute a dramatic change in use. It is the complex is still primarily and overwhelmingly residential or a long-term residential area. That's not to say that we can't do more work into this into the future to get some more advice on this. But I think as to the concerns of the complex going forward, I think ultimately this is one that the residents need to sort out through their body corporate. I think they are actually doing that. And that's probably the more appropriate way to address this, because ultimately this does comply with the rules, and it is an approved use. So I think this is something that I'd be encouraging everybody to support, and I also do support the motion. I'm not sure if that comes to council tonight, but the additional motion that Councillor Harvey put forward as well to try and get some long-term knowledge on what's going on in that complex.
Deputy Lord Mayor.
I rise to not support this, to foreshadow a recommendation for refusal, and that's based on grounds in relation to the proposal does not satisfy subclause 3, because if this proposal was approved with visitor accommodation would not be of a scale that respects the character and use of the area, and B, the proposal does not satisfy subclause 6 because there is an unreasonable impact on the amenity of the long-term residents of 1 Collins Street. Lord Mayor, this is the second application for short stay accommodation that we've heard in the last couple of months for this residential accommodation facility, and I think it flies in the face of what we should be doing in the Wapping area. When the Sullivan's Cove planning scheme was put together, there were a number of parcels of land for the Wapping area, and I think this falls under parcel 5. And so this activity area 1, inner city residential, and I quote from the Sullivan's Cove planning scheme, the general characteristics of the activity area. The Wapping activity area has been earmarked for significant redevelopment for residential purposes in the early 1990s. Under 15.2, the objectives of the activity area, points 1 and 2, to provide for the development of an inner city residential neighbourhood, providing quality urban housing for a range of household types and income groups, to ensure that residential development is the primary focus throughout the activity area. And so here we are seeing an erosion of residential facility or residential amenity, residents in the Wapping area. Not only that, and I think it's particularly noticeable when you have people in a residential complex where you get these changes of one, then another, to short stay accommodation. And whilst that, we hear the reasons why applicants put in their applications. Somebody wanted to protect his $1 million asset by renting it out or leasing it out for short stay accommodation. And we hear from this applicant today when we had our special committee meeting to consider it. But we also heard from representatives, some of us would have visited the complex, and they are concerned that their amenity is being eroded, and it's being eroded, and I can see it before my very eyes, if not all of us can see that this is being eroded. It's really difficult to say that somebody who pays a lot of money for short stay accommodation will be less likely to have loud parties. I don't know if that actually works like that. Not sure, but I don't think we can argue that, and I don't think this application protects those residential amenities. Therefore, I'll shadow my grounds for refusal.
Alderman Briscoe.
Yes, very briefly. Last time we passed a similar apartment in the same complex, we gave it a 2-year limit. and there was no appeals. This time, the wisdom of the committee was as well, and I suggested that we have a 2-year period to assess whether there is in fact any adverse impact. Now, a little bit of history. The body corporate rules did disallow holiday accommodation, short stay holiday accommodation. The rules were changed by the body corporate. So at some point in time, the body corporate decided to allow short-term accommodation. They're in a process, we've heard, of reverting back to the original rule. All short-term stay accommodations have rules to do with no parties. So I think the officers have recommended approval, and we have allowed, we have put an extra condition about the time limit permit for this permit for 2 years. At the end of the 2 years, we'll have evidence or not of whether this use continues. Now, the planning rules do allow this. The directive allows it. The performance criteria have been met by our officers. Now, we can all have pie-in-the-sky, idealistic views about this, but the body corporate allows it, which is not our concern, but the body corporate allows it. It may change in the next month or so. Our planning officers have assessed that it's minimal impact, and in 2 years' time the council will have evidence or otherwise of any adverse impacts, and that will guide our decisions. So I think it's a win-win-win. If the residents last time, the last application a month ago or so, did have any concerns about that 2-year limit, they would have put in an appeal. So I think this we can pretend that all the things I've said are not true, but they are, and have this glorious view that it's a residential area. It is certainly a residential area. There are 60-odd apartments there, and if you add in the apartments nearby, the predominance of apartments. But you've also got the Theatre Royal, which had a massive extension with the Herberg Centre. You've got the hospital not even a block away, where it just had a massive refurbishment, a new block, K block. You've got a hotel in the corner. So you look around, it's not a pure little Lena Valley type community of residential thing. It is mixed use, and under our planning scheme, if it's mixed use, we're allowed to have, the applicant is allowed to have, apply for short-term accommodation. So if we ignore all those rules, then I think we would be not doing justice to our planning scheme.
Thanks, Lord Mayor. This was the 6th short stay accommodation in this block, and there's a 7th one coming as well. So the 7th one will take this up to over 10% of the flats or units in this complex that have been turned over to short stay accommodation. So I think, personally, and I think people around the table probably agree somewhat, that there needs to be a ceiling on how many units within a complex can be turned over to short stay accommodation, and I think the ceiling has been reached. So it went from 5 to 6 today, and then there's one we'll go from 5 to 6 today if this is passed, and then one more coming in the future, so that'll take it up to 7, which is 11%. And I just think that's way too high. I'd like to think that at some point a ceiling could be established that prevents the takeover of these complexes by short stay accommodation. I don't understand the needs of the residents, but I also, the owners of these properties and their desire to have short stay accommodation to maximise their investments, but I also see the needs of people needing to have a secure home. And I do understand that a lot of renters live in this complex as well, but they're permanent and it's predictable. They're there all the time, so they get to know the neighbours. There's a difference between having short stay accommodation in the complex and having permanent residents in the complex.
I think, as the Deputy said, that does affect the amenity of the complex for everybody.
Alderman Thomas.
Yeah, look, I think we're assuming quite a lot here. Until we have a policy, until there is a directive or something at law which says what we can do to contain how many people have short-term or long-term rentals or no rentals at all, I think it's really dangerous for us to be working on a supposition that we think that 6 is too many or 7. 6 is okay, but 7 might not be. We regulate... Sorry?
Sorry, just to clarify, not rentals, it's short stay we're talking about.
We've already had this situation. I was quite offended by the fact that short stay people, of which probably a lot of us around this room have gone and short stayed at different places over the years, don't necessarily create mayhem and noise. In fact, when you come back from a night out, and you probably go very quietly back into your room and enjoy peace and quiet. The reality, we'll never know that. But what regulates, for me, what regulates first off is the body corporate. We have a body corporate which is usually quite restrictive about what can or can't happen in a complex to preserve the amenity and the overall condition of the site, including common property. We have a body corporate. The body corporate is not refusing and has actually said it is okay. When the body corporate says it's 12%, 15%, 20% or 96%, then that's when we should listen, unless this council is going to do a deliberate study and require a piece of work to come back to a future council meeting and legally make a supposition. We should be very careful where we're treading here.
Can I just add a point of clarification? I think Alderman Thomas is making a good point, and I think there is a report coming back in relation to short stay accommodation. Is that not right, Mr Noy?
Through you, Lord Mayor, that's correct. It'll be coming back in the next either next planning committee meeting or the one after on this very issue.
Alderman Zuko.
Yeah, Lord Mayor, I thought I was here to make decisions under the planning scheme, not worry about whether or not the ceiling's going to fall in or not, because I think that's what we're sort of looking at here, trying to pluck something out of the sky. Through you, Lord Mayor or General Manager, to the Director of Planning, can you please direct me in the planning scheme where we have to have a ceiling on short stay accommodation, please?
Would you like to brief Alderman Zuko on the planning directive?
Yes, thank you, Lord Mayor. Look, certainly the scale of visitor accommodation is a criteria under which we will need to consider discretionary applications, and I refer you to section 6.7.8 of the report and beyond that goes into that issue of the scale of visitor accommodation that might exist within a complex.
So could you advise me what this complex limits are?
Well, it's a qualitative judgment, Lord Mayor, so there's no quantitative standard.
So you're saying there's no limitations on this particular property? Is that what you're saying?
Well, what I'm saying is that the actual provision that I'm just looking at.
Well, can I rephrase the question, Mr. Noy, if you wouldn't mind? Yeah. Mr. Noy, can I rephrase the question? Yep. Through you, Lord Mayor.
Sorry. Yes.
Just rephrasing the question. Is the limit on this particular property 5, 6, 10 or 20?
Through you, Lord Mayor, none of the above. The provisions stipulates that the proposal should be of a scale that respects the character and use of the area.
So thank you, Mr. Noy. So under the planning scheme, there's no ceiling. This is the whole thing about planning. Planning is, at the moment, if we want to have a ceiling on visitor accommodation, it's something you should do under the planning scheme. But you can't determine it by specific properties and specific buildings. But on the other hand, we have had quite a number of long-term accommodation and apartments that this council has also refused. Now, if our argument is we shouldn't approve any more visitor accommodation, well, maybe those people who voted against quite a number of applications over the time, whether they got approved or not is a different matter. But if we're serious about doing something about the rental market and the apartment market, maybe we should consider the way we vote in respect of general apartments and a
Point of order, Lord Mayor. This is irrelevant. We're discussing a particular short stay accommodation unit, not residential development in Hobart. So can we please be relevant to the debate?
Lord Mayor, there was argument there was argument in respect of visitor accommodation. Yes.
Could I make a ruling on the point
Yes.
of order? Look, I don't think it is irrelevant to the motion, but if you could just get back onto the specific building now, Alderman Zuko.
Well, it's not irrelevant, Lord Mayor, because the mere
I've
fact.
just made the ruling.
It's fine. It's okay. You said it wasn't irrelevant, and I'm just making a point. It's fine. I'm making a point, Lord Mayor, that the argument was put to this chamber in this evening in regards to the amount of visitor accommodation, and the Lord Mayor was stating that this area was predominantly residential. So the argument is there. And actually, when something is predominantly residential, doesn't mean that it be solely residential. Anyway, I like the fact that on a regular occasion that I get up to debate, there's always that regular point of order called, which is absolutely fantastic. But I've got to say, the actual aspect of whether or not we have a ceiling in respective buildings on visitor accommodation should be up to the body corporate, not this council, unless we decide to do something under the planning scheme. It meets the criteria and it meets the planning scheme.
Councillor Dutta.
Thank you, Lord Mayor. Just a few questions. Firstly, a statement was made with regards to the fact that the objective states clearly that it's for residential purposes. Now, I just want clarification on this. Is this true, and can this be used when we're making a decision with regards to this matter as an objective?
Mr. Noy.
Through you, Lord Mayor, in a general sense, the priority is given certainly to residential land use. However, it does not preclude other uses, and there are certainly provisions within the planning directive that does envisage short-term visitor accommodation being allowed in certain circumstances, and that's what we've assessed it under.
Thank you. Thank you for the clarification. And the second question I have, Lord Mayor, is with regards to the character and use of the area. Can I have a definition of what constitutes character in this regard, please?
Yeah, well, yes, through you, Lord Mayor, certainly the character is primarily residential, although there are other, again, uses present within the area, including short-term accommodation and specifically within the building and the complex itself. So it is predominantly residential, but there are a number of other uses, visitor accommodation being one within the area as well.
Thank you. Now, I am of the view that, I am, the last time I debated this, I was strongly of the view that I wasn't going to support this to go ahead. Now, my change in my position today is that I've read it and the arguments I've heard, if it is primarily for residential use, but there are these options that we have, and what I heard from the applicant and the resident, as it were, and the fact that there was this amendment put for 2 years, I feel a bit more comfortable with that. And therefore, I am going to be supporting this because of that condition that is placed there. Thank you.
Further discussion?
Can I just ask some questions, Lord Mayor, for the director? Sorry to get you while you just sat back down. Just to clarify, the clause 15.2, does it say that we're ensuring that residential development is the primary focus throughout the activity area, or are we trying to ensure that residential development is the sole focus of the activity area?
Through you, Lord Mayor, it's not the sole focus.
The primary focus. So just a supplementary to that, in the views of the planning department, would residential use of over 90% be considered a primary focus?
I would agree with that statement.
Thank you, Director.
Any further discussion? I might just make a few points. I think I commented on the last one as well. Look, I think I did want to clarify with the director, because I think there might be a little bit of confusion around the table that about this the planning rules that do govern this area. So can I just clarify, we're obviously dealing with Planning Directive number 6, which is around visitor accommodation, which came in only a couple of years ago from the state government, so it's quite new. Does this planning directive specifically set particular rules for this part of Hobart?
Lord Mayor, that's correct.
So there's quite, so under the planning rules, this isn't just sort of, random rules around visitor accommodation that could affect any part of Hobart. There's very, very strict and specific rules for this area that relate to visitor accommodation. And that was the purpose of the government when they passed them, to create quite specific rules.
Yes, when they amended the directive, they brought in some specific provisions, noting that there were prohibitions before this directive came into place. The first iteration of the directive was a much more liberal allowance for this land use, and subsequent changes, I think in response to the concerns expressed by this council around Badgery Point and Wapping, there were further restrictions put in place. That's correct.
Because I think it's really important to realise that the concerns around this are not just sort of general, random, unspecified concerns about visitor accommodation in Hobart. We are actually grappling with some very, very clear rules in the Planning Directive number 6 around visitor accommodation in this part of Hobart. And it is very discretionary. I mean, this is a discretionary planning application, and we're doing our job to decide whether it should be approved or not. There's many things about this application that are prohibited, but with our discretion we can overlook those. Around the floor area is set. There's obviously the things we've been talking about with visitor amenity, but it is really important that in this debate we do realise that that in the discussion around the inner city residential Wapping area, there is a different standard of rules. There's a different hurdle to jump over, and so all of the concerns and discussion that have been raised are very much planning considerations that have to be taken seriously. So, thank you. I think that's all I need to say. Deputy Lord Mayor, Alderman Brackus, did you want to sum up?
Very, very briefly, Lord Mayor. Look, I'll just start by correcting something that Councillor Harvey said. There was talk of, with all of the short stay accommodations in this complex will make up 11%. I think that was counting a application that's yet to come. We can only make our assessment based on what's in front of us and what the current state is at the moment. We can't be speculating into the future based on an application that we have in front of us. The correct number is, if this application should be approved, the makeup of visitor accommodation on the complex will go from 7% to 9%. That does make that will remain that the residential component of the complex, the long-term rental component of the complex, will be over 90%, will be 91%. given that section 15.2 does specify that, the residential development is a primary focus throughout the activity area, I think anybody would reasonably say that when long-term residential use is taking up 91% of the use of the complex, that is the primary function of the area. The scheme and this clause does not say it's the sole area, so the suggestion that any deviation from what we currently have would be not compliant with the planning scheme, I think is fundamentally incorrect. And I think, Lord Mayor, I think you are correct. I think we are sort of being asked to exercise our discretions here, but I think we do have to acknowledge that what we have in front of us does meet all the requirements that it's set out to meet, and I would be encouraging everybody to exercise their discretions to uphold the recommendations of the planning officers here in this case. Look, I think the suggestions and the amendments that Alderman Briscoe put forward, I think, do help meet the gap between the concerns of the residents, and I think they are genuine concerns, and the rights of the applicant here to put forward what he's putting forward. And I think if we can have a management plan that helps residents put forward their concerns and get those concerns acted upon, and get some accountability for if there is non-compliance or there is misbehaviour, I think that goes a long way towards bridging that gap. And at the same time, this is something that is only set to be in effect for 2 years. If this
30
does,
seconds.
thank you. If this does come back and this does, the effect on the residents is greater than what the council anticipates, we can just choose not to reissue that. So I think I'd be encouraging everybody to support the officer's recommendation on this one, because I think it's only reasonable.
Lord Mayor, sorry, could we have consider Part A and Part B separately, please? Because I'd like to support Part B, but not necessarily Part A.
Yes, I think that's okay. So I'll put the Part A of 9.5. All those in favour say aye. Against say no. Show of hands. All those in favour.
Alderman Zunico, Alderman Sexton, Councillor Dutta, Councillor Coates, Alderman Barakis, Alderman Thomas, Alderman Briscoe.
Against?
Councillor Harvey, Councillor Sherlock, Councillor Ewan, the Deputy Lord Mayor and the Lord Mayor.
Carried, Lord Mayor, 7 votes to 5.
And now we'll put Part B. All those in favour say aye. Against say no. It's carried unanimously. Okay. Item 10, building statistics.
Lord Mayor, I'd like to move that these be
Second, Lord Mayor.
received and noted.
Second by Alderman Briscoe.
So these are the building statistics for February 2021 compared to February of last year. So we have had 46 permits issued to the value of $17 million this February, and that included 32 extensions or alterations, 7 new dwellings and 2 major projects, which were over $3.9 and $3 million each of those. The period this time last year there were 37 permits and the value of that was $188,000. So sorry, the value of that was $243 million compared to the value which is less in this last 12 months, which is $188 million. So that's for the 12-month period. Sorry. So something is, well, it's continuing to be buoyant. However, the overall value has reduced to some degree.
Okay. Further discussion?
Yeah, Lord Mayor, look, this is a comparison to 2020, 2021, which is great to see. 21, we're starting to, get there. But if you look at February, March and all, actually the February is when COVID started hitting our shores. It'd be good to, if we wouldn't mind, just for the next 6 to 12 months, put in 2019, because I can just foresee March's coming and, March's figures are going to be absolutely, and then April might be not so good because of the COVID scenario in 2020. It'd be good to have a look at 19s as well over the next 6 months, just to sort of see the comparison to 19 un-COVID and 21, because I believe 21 is going to be, on the rise, and 20 would have been on the dive. So the director's noting that just for the next 6 months, because that way there we would get an understanding of what happened in 19 without COVID, 20 with COVID, and 21 with sort of COVID sort of on the way out. So do I need to move it as an amendment? I'll take it on notice. Thank you.
Lord Mayor.
And I think some of the data that's being kept by the director is actually 5-year data too, isn't it? Or you report on some of your 5
Got a 5-year comparison graph.
Okay, well I'll put that. All those in favour say aye. Against say no. Carried unanimously. Item 11 is the Finance and Governance Committee, the 2021 Annual Report Progress Report. Alderman Zuko.
Yes, Lord Mayor, it's the progress report. The Council endorsed the annual plan for 2021.
By Alderman Thomas. Any discussion?
Can I just ask the General Manager to give us a brief overview or some of the highlights of this plan for the year, or some things we should take note of?
Yeah. Look, maybe, Lord Mayor, just to say that we are progressing through. There's probably 3 items in the annual plan that we're going to struggle to meet because of our COVID restrictions, and they're outlined in the report. But look, I think in a COVID year with tough resources and a smaller budget, we are still meeting the majority of our issues, activities, if you like, that we indicated in our annual plan. The report does detail what those particular items are that we're going to struggle to meet by the end of this financial year.
Okay, no further discussion. I'll put that. Oh, did you want anything else? No. I'll put that. All those in favour say aye. Against say no. Carried unanimously. Item 12.
Yeah, City of Hobart contract management policy that we adopt the new policy.
Is there any discussion on this? Oh, seconded by Councillor Sherlock. Any discussion? I'll put that. All those in favour say aye. Against say no. Carried unanimously. Item 13.
Lord Mayor, this is the Australian Local Government Association call for motions. There's one motion that the National Assembly calls upon the Australian Government to ensure the fair balance is made between the requirements of telecommunication carriers in regards to the 5G technology.
Seconded by Councillor Sherlock. Alderman Briscoe.
Just a question. Is the Australian Local Government Association National General Assembly will be meeting in person this year? And yes.
Is that
that's a question, yes.
It is my understanding that it will be, Lord Mayor, yes.
And that's in October, is it, or?
No, it's in late June, Lord Mayor, in Canberra.
Okay, thank you.
I think the item 2 of this is the council determine if they want to put any other motions to ALGA. So, any motions from the floor? Can I just ask where this one came from? Was this, it seems like a triple CLM sort of...
Oh, the 5G.
Through you, Lord Mayor, there has been a discussion at the triple CLM level, and there's general discontent across most councils across Australia with the current Telecommunications Act, which gives the telco providers free access to put their infrastructure anywhere. So just looking to make some amendments to the existing legislation.
Okay, I'll put that. All those in favour say aye. Against say no. Carried unanimously. Alderman Zuko, item 14.
Yes, Lord Mayor. This is a review of the City of Hobart's financial hardship policy. This was actually... I'll put the motion.
Seconded by Alderman Barakis.
Yes, Lord Mayor, there was quite a considerable amount of debate in respect to this, and the council has decided to set a defined date, and the defined date will be March 31st. But there are, as we are aware, under the Act, there are also other avenues for people who may display hardship, and I so move.
Further discussion?
A question through you to the General Manager. The original recommendation was to continue with this. Is everything picked up in this motion now that wasn't, which was covering financial hardship for, in particular to COVID applicants? If that makes sense.
I don't know. I'll attempt to answer it. The original recommendation we put to the Finance Committee, Lord Mayor, was that we continued the hardship policy for COVID for the hospitality sector. And that was part of the officer recommendation, together with reducing the delegation for COVID from $4,000 to $3,000 to the General Manager. It's fair to say, without wishing to labour the point, that the Finance and Governance Committee were not attracted to the proposition at all, and were firm in their view that the hardship policy for COVID cease on the 31st of March, together with the media strategy to alert people to that fact. So the original officer recommendation, Lord Mayor, was to continue the COVID-19 though for hospitality.
Thank you, General Manager. And I certainly was at that meeting and did vote in support of this current motion. However, I have been thinking about it, and I have been looking at various maps where we're seeing the most impact from COVID for businesses, and we're finding that in capital cities, including Hobart and I think Cairns, they're likely to be the hardest hit. So I'm in two minds about this, to be honest. I feel like perhaps the original recommendation, which really looks after Hobart businesses, should be reconsidered with the appropriate levels to be amended for $4,000, I think, for your jurisdiction or your consideration, delegation, General Manager. So I'll foreshadow that we continue with the Hobart financial hardship assistance policy, given we have some fairly uncertain times for businesses, I feel, and whilst there are things that are covered by our general hardship provisions, perhaps our businesses are going to find it very difficult. And we know full well that there are businesses which have applied not once, but on more than one occasion for support. Now, whether there are other things at play, who can say? But certainly we're finding ourselves in these extraordinary times, and perhaps as a council we should be considering that. So I'll foreshadow the original motion subject to the appropriate delegation.
Alderman Briscoe.
Yes, so just a question through you to the General Manager. I have a certain sympathy for the Deputy's point of view about this, but we are having a workshop tomorrow, and I'd like to tease out that how much it would cost us and get some modelling of that. I sense that Hobart particularly is just my feeling of walking around the streets, and it is a feeling. And Salamanca on Saturday, there's heaps of tourists that have arrived here during March, and April apparently there's anticipated more. So I think that Hobart is unique because it is an overseas destination for most of Australians, and as I said, I feel sympathy for the viewpoint put by the Deputy, but I haven't got any information to base a decision on it other than the decision that's come from the officers. So all I can say is it an appropriate thing to discuss briefly tomorrow?
Can I just be clear exactly what it is you wish to discuss
tomorrow?
tomorrow?
Well, if we extend the hardship provision,
do you mean?
Rather than stopping it on the 31st of March, what would the effect on budget?
Look, Chairman, Lord Mayor, we've certainly done some modelling on that, and we could certainly present that modelling tomorrow night at the budget workshop that we've got. So we're in a position to do that. You could, if you wish tonight, defer it. We do have a council meeting again on the 31st of March. I am mindful, though, that this is a hard cut-off date of the 31st of March as well.
Yeah.
But we could do that modelling and we could present that tomorrow night to the budget workshop, Lord Mayor, if there was a motion for deferral.
Yeah. Look, I'll test the waters, Lord Mayor. Motion for deferral.
I need a seconder for that. If there's,
Can I?
Yeah, I think you can. Yeah. No.
Alderman Barakis, seconded. Yep. So.
Yep. Okay, so that's a deferral motion. I'll put that. All those in favour say aye.
Aye.
Against say no. Show of hands. All those in favour? Carried unanimously by the looks.
Yes.
Okay, so that's been deferred till after our workshop tomorrow.
Sorry, Lord Mayor, before we...
Yeah.
That's fine, of course. But is there a way in which it's not just an issue of council's ability to, what it might be up for, but is there any way, and Mr Short, I don't think, Mr Short is here, through you, is there any way we can get the assessment? Because exactly as what as somebody just said, there's a huge splurge in tourism and hospitality. You cannot rent a car in this city for less than several $100s a day in some instances. There is restaurants and accommodation. I'd like to know, before we sit back and talk about our ability to pay or what it might cost us, to get an idea genuinely out there as to what is going to be the impact on Hobart businesses between now and the end of the financial year.
Right. That's a really good question for you, Lord Mayor.
It is.
We will have...
If you do say so yourself.
We will have as much information as we can possibly pull together between now and tomorrow night to seek to address those concerns.
Lord Mayor, again, sorry to... I need to ask this question because there was a proposed media release to go out that we were going to stop this. I think it would be prudent that a media release go out that the council is considering it. At least that way there it does send a message out to the general public. So if I may, Lord Mayor, can I have move that the item be reconsidered, that the deferral motion add that we put a media release out that there could be consideration that it may stop.
I don't think we need to, because we'll do an update from this meeting, which will say it was deferred, but it'll be considered again soon. So that'll be in our update from this meeting.
The question is, when is it going to be considered? The 31st of March is next week. But anyway, it's all right. I'll just sit down and mind my own business.
All right. So I'm going to move now into the closed portion of the meeting. So moved by Deputy Lord Mayor, second by Alderman Barakis, and we'll say good night to people on YouTube.